you go. My little lady friend.
So shall we call the meeting to order, or can we just turn it right over to Mike, Donna?
Just call it to order. I don't think you need to do a roll call or anything like that. It's not required. And then just hand it over to Mike.
Okay, fine. So at Donna's request, Mike is here to talk to us about recent and maybe not so recent changes to the laws that govern what we do in land use. And thanks for being here, Mike, and I'll turn it over to you.
Okay, very good. I'm going to try sharing the screen, see what happens. Seems to have worked.
Hey.
Can you all see it?
Yes.
Okay,
Yes.
good. Yeah, so as Betty Davis said in the movie All About Eve, fasten your seatbelts, it's going to be a bumpy ride. There was a lot of stuff that the legislature did in the last month of the legislative session. So there's a lot to talk about. Matt, you said, this year and maybe before. Going through this year, you're gonna be exhausted by the time we get to what they did this past couple of months. So without any further ado, let's go right to it. The major public acts are 21-29. I have to just move something out of the way here so I can see it. Let's see how I do that. Yeah, let's put it over there. Okay. Major public acts are 21-29, and that is probably the biggest of them all. That involves several different functions and several different ideas that we're going to talk about separately. 21-34, if you look at the title, you can see that there's not an awful a lot in the title that seems to apply. Most of what 21-34 is an extension of the various time limits that virtually all of the land use commissions would otherwise have to deal with. And most of them are extending permits for as up to 2019 and so forth. So we'll talk about those individually, but that will go fairly quickly. The next item is the 21-1 that was passed in special session. That is an enormous bill, probably one of the lengthiest pieces of legislation I've ever seen passed, other than the implementer bills. And that's the one involving marijuana, the new regulation of marijuana and allowance of marijuana. Special session 21-2, that is the implementer bill, which is just as long as the marijuana bill, but again, contains just a few provisions that we're going to have to deal with. 21-101, most of it is just a few issues involving affordability. 21-3 is an act that temporarily extends the provisions that the governor ordered by executive order during the pandemic, during the heart of the pandemic, allowing outdoor sale of goods and provision of food and beverage service. So we're going to jump right into 21-29, and we'll talk about the key provisions. Now, what I wanted to do with this first slide is to show you, if you're not familiar with how the legislature operates, this is typically the way they deal with a statute that already exists. When they pass a public act, in this case, Public Act 21-29, in order to find the provisions of 21-29, nobody's going to remember what was in 21-29. What the legislature has to do is incorporate those provisions into statutes that are organized by title and subject matter. So Section 8 of Title 8 of the general statutes is the one that deals with zoning issues. So what they'll do when they have an existing statute that deals with zoning issues is they'll say, Section so-and-so of the general statutes is repealed and the following is substituted in lieu thereof. And often it's a very lengthy section and they're not really changing most of it. But when they do make a change, the way they show that is by additions that are underlined. So you can see those here. And any provisions that they are going to strike, they put a strike through them. They didn't have any in this particular case. They're just adding language to 81-C of the general statute. So that's just showing you how they do it. So when you see this provision, you'll ultimately see it in section 8-1C of the general statutes. And again, that's so when you go in to find a statute, you don't have to try to remember where it was in the legislative process. 21-29 won't mean anything anymore. And in this case, 21-29 creates a lot of new provisions of law, as well as amending some existing provisions of law. All right, so what are these key provisions? Let's go over them in some detail. Section 2 of the Public Act, it differentiates between ordinances and regulations. So I'll go back and show that. A municipality may, by regulation, require any person applying to a municipal zoning commission, planning commission, etc., to pay the cost of reasonable fees associated with any necessary review by consultants, etc. The purpose of that is, surprisingly enough, there are very few statutory provisions that existed prior to this that allowed zoning commissions and some other commissions to charge fees for land use applications. There really aren't very many. There's one for planning, there's one for inland wetlands, but there wasn't anything for zoning or zoning boards of appeal. So you can see the old provision of 8-1C allowed a municipality to establish a fee by ordinance for zoning commissions as well as other commissions. And then it said that schedule shall supersede any specific fees set forth in the general statutes or established by a planning commission. So what that meant is, back before this act was passed, the only way that a zoning commission could charge fees for applications was if there was an ordinance. Planning commissions could charge fees under their own provision, but they had certain limitations as to what they could do. So this section allowed the town to act to create an ordinance to allow the agencies to charge fees. But the problem is, an ordinance has to be passed by a town's legislative body, which in the case of Kent is the town meeting, I believe. So a zoning commission couldn't directly do anything. Subsection B, this new subsection B, now allows all of these commissions, zoning, planning, combined planning and zoning, zoning board of appeals, or inland wetlands, to charge for the cost of reasonable fees associated with necessary reviews by consultants with expertise in land use of any particular aspect of such application. So this relates specifically only to consultants and consultant fees. And it says any such fees shall be accounted for separately from other funds of the commission or board and shall be used only for expenses associated with the technical review. So you have to have a separate account for these kinds of fees so that they can be separately audited. And then it also says any amount of the fee remaining after payment of all expenses has to be returned to the applicant not later than 45 days after completion of the technical review. Now, this is going to cause some issues that we'll talk about in a second. And then if you look at subsection C, no municipality may adopt a schedule of fees under subsection A of this section that results in higher fees for development projects built using the provisions of section 8-30G, which is the Affordable Housing Appeals Act, or residential buildings containing 4 or more dwelling units than for other residential dwellings, including but not limited to higher fees per dwelling unit, per square footage, or per unit of construction cost. I'm reading these now because it's far more complicated than it might seem at first blush. So first of all, I would say, notice that subsection B gives zoning commissions and other agencies the right to charge consultant fees, but not application fees per se, other than consultant fees. So you'd still be relying on subsection A ordinances for your normal applications fees, but you can create a separate provision for consultant fees. And then subsection C is a limitation on what subsection A can do. And it's now saying that there are certain types of multifamily structures for which the fees are limited to the kinds of fees that would be available for you to charge for other residential dwellings. But it really is not clear what that last clause means. So I'm going to go to this next one. The takeaways are, number one, the 81C now differentiates between ordinances and regulations. The regulations would be passed by the agencies normally responsible for them, but the reference to the municipality creates an issue. If you go back to this and look, it says a municipality may by regulation create that. Usually when the legislature is talking about the municipality, they're talking about the legislative body. But here, I think they meant to be talking about the agencies, but they didn't say that. And so what you're going to see is a lot of this legislation is just very sloppily drafted. And it's going to create a lot of unnecessary issues because of that, or it could. Hopefully, common sense will prevail and we won't have many of these issues, but lawyers are paid to argue about, issues and split hairs. So I think that could very well happen. All right. Fees set by regulation must be sequestered and the excess must be returned to the applicant within 45 days of completion. So here are the issues. It implies, but it doesn't say that prepayment of estimated fees may be required. In other words, how do you get the fees in the first place? It doesn't say that you can pre-order them. So you're going to have to figure out, do we get to ask for them a month in advance, 2 months in advance? That issue was left open by the legislation. It refers to interest. Again, notice it says that any amount of the fee, including any interest accrued, you'll see my cursor going over that, shall be returned to the applicant. Does that mean that you have to put it in an interest-bearing account? It doesn't say that, but somebody might argue that. So again, who knows? Also, it's not clear what will happen if the consultant fails to submit invoices within 45 days of the completion of the review. Or to what I should have said, if the consultant fails to respond to your request for invoices. If your consultant doesn't get you the invoices in time and you have to return the balance to the applicant within 45 days, you could be screwed. The legislation doesn't provide any protection for that. Like I said, the prohibition against higher fees for 8-30G developments is not clearly written. As an example, it's uncertain whether it would preclude a municipality from charging a higher total consulting fee for a building with 4 or more dwelling units than for a single family home. Let's go back and look at what it says. No municipality may adopt a schedule of fees that result in higher fees for residential buildings containing 4 or more dwelling units than for other residential dwellings. So does that mean you can't charge more for a 4 dwelling or 5 dwelling or 10 dwelling unit than you can for a single dwelling unit? It kind of says that, but I don't think they meant it, but it creates yet another issue. So just a bad job of drafting, I think. All right, Section 4. There has long been discussion in the legislature about reorganizing Section 8-2. Section 8-2 was the heart of zoning statutes for many years. It was the fundamental part of the Zoning Enabling Act. And it used to be quite short, but over time it got longer and longer and longer and longer as the legislature kept adding provisions to it. And it finally got to the point where people were saying, look, you start out by saying you have to do this, and then you may do that, and then you have to do this, and you can't do that, and you may do this. And somebody said, look, let's reorganize this so we can finally, have all in one place. Here's what you got to do. Here's what you may do, and here's what you can't do. So that's part of what is going on here. And you can see now in this particular page how they did it. You can see where for instance, right here, where the underlines are, where language was added, and in the red, where language was taken out. a lot of the language that was taken out really wasn't taken out per se, but it might have been moved from another section as they revised and moved the various cans, shalls, and mays and can'ts to different places in the legislation. So that just shows you how they were going about doing it. This is the same thing. Okay, just the same part of that. Whoops. Let me show you a couple. I went too fast here. Let me show you a couple of things that are interesting about it. If you look up in subsection B2 here, it used to say zoning regulations shall be designed to provide adequate light and air and to prevent the overcrowding of land and to avoid undue concentration of population. That language is now gone. That language is gone because of the new focus on creating more and more multifamily housing. So basically, the legislature is saying, we don't want the provisions in 8-2 saying that zoning regulations have to consider overcrowding of land and have to consider avoiding undue concentration of population. We don't want those to be used to prevent multifamily housing. So we're just going to strike those. It doesn't actually say that you can't do it here, but it's been stricken from the language that says you have to do it. Now, if you look at the language that was added, the regulations can now consider the impact of permitted land use on contiguous municipalities and on the planning region. So they're focusing now on more regional analysis. They can address, or they shall address, I should say, significant disparities in housing needs and access to education and occupational and other opportunities. So again, you can see that new focus on housing and housing needs. Promote efficient review of proposals and applications. So again, we're not sure what that's ultimately going to mean, but affirmatively further the purposes of the Federal Fair Housing Act. And one of the questions is, how do municipalities do that? We'll talk about that briefly. I have to go through all of these very fast because there's so much of it, but those are the kinds of things that caused me to scratch my head and said, what is that ultimately going to mean? Here's another one. You used to have to draft the regulations with reasonable consideration as to the character of the district. Now, character is a no-no. Now you are substituting physical site characteristics for character because the legislature said character is too loosey-goosey a word. Too many commissions have denied multifamily housing because of the character of the neighborhood. So we're no longer going to allow that. Now the character has to be related to, or has to be defined by specific physical site characteristics that you're going to be talking about. All right, so those are the most important parts of that. A lot of this is just shifting of material that you're seeing in these sections. But here is some new stuff. Zoning regulations adopted pursuant to subsection A shall not prohibit the operation in a residential zone of any cottage food operation. Why that made the cut, I don't know, but that was a focus of this legislation, and there it is. Establish for any dwelling unit a minimum floor area that is greater than the minimum floor area set forth in the applicable building, housing, or other code. That's very limiting. I don't know that Kent actually does any of that anyway, but that's a very limiting thing. There are many towns that had regulations saying we have to have a minimum square footage for any dwelling unit of X. And now the legislature says, no, you can't do that unless it's a minimum floor area that's set by some applicable state code. You can't place a fixed numerical or percentage cap on the number of dwelling units that constitute multifamily housing over 4 units, middle housing, or mixed use development that may be permitted. We'll talk about those definitions in a minute. But what that essentially means is you can't say we shall have no more than this number of this type of
Join the meeting
in the town. I'm sorry, did somebody say something? Okay, I'll keep going. You can't require more than one parking space for each studio or one bedroom dwelling unit, or more than two parking spaces for each dwelling unit with two or more bedrooms, unless the municipality opts out. That's a very unusual provision, and we'll talk about that in a minute. And here you go. They can't be applied, the regulations can't be applied to deny any land use application on the basis of a district's character unless the character is expressly articulated in such regulations by clear and explicit physical standards for site work and structures, or the immutable characteristics, source of income, or income level of any applicant or end user other than age or disability, whenever age restricted or disability restricted housing may be permitted. So what that means in general is character, again, is a no-no. It has to be specific physical criteria now for what you mean by character. And the second one just says you can't deny an application on grounds that relate to a specific category of user. Again, I don't think Kent does anything like that. I'm not sure what towns that was meant to address. Maybe there's some town that had some provision like that the legislature just wanted to make sure couldn't do it anymore. I don't think that's anything that Kent has to worry about, but it's in there. All right, so here are the key definitions. Middle housing means duplexes, triplexes, quadplexes, cottage clusters, and townhouses. Mixed use development means a development containing both residential and non-residential uses in any single building. A cottage food operation means any person who produces cottage food products only in the home kitchen of such person's private residential dwelling and only for sale directly to the consumer. In other words, a mom and pop operation. Cottage food products are defined over in 2162B, which you see there. And I got a kick out of the definition, non-potentially hazardous baked goods. They actually have a definition of what are the potentially hazardous baked goods, but to say that you can offer non-potentially hazardous baked goods is just seems to me a kind of a tortuous way of making the point. All right, takeaways and issues. Section 4 arguably eliminates the opportunity to consider regulations to prevent the overcrowding of land or to avoid undue concentration of population. Now, unlike the provision for character, although they removed the reference to overcrowding of land and undue concentration of population from the shall consider category, they didn't put it into a prohibited category. So it's not clear whether you can still consider those things. It says you don't have to, or it doesn't say anything anymore about whether you can, but it doesn't say that you have to anymore. But whether you can, a court conceivably could conclude that, well, the legislature, by taking it out, meant to say that you can't consider those things anymore. So again, because it's sloppily written, it creates an issue that didn't need to be there. Here's an interesting thing. It affirmatively allows consideration of tribal and cultural resources, as well as environmental and historical resources. That's brand new. Requires the regulations to consider and address local and regional housing needs and to affirmatively further the purposes of the Federal Fair Housing Act. So it's not only unclear what that means, how you affirmatively further the purposes of the Federal Fair Housing Act, it's also not clear what a court might do if it finds that you haven't considered that. I don't know whether the court will say, well, you can't enforce some regulation, or you know, there's something that you're precluded from doing now. It's really not clear what's going to happen if you're found not to be affirmatively furthering the purposes of the Federal Fair Housing Act. And again, the problem is we don't know what that means in the first place. So we're all going to have to be figuring that out over the next few months. It prohibits requiring more than one parking space for each studio or one bedroom dwelling unit, or more than two parking spaces, etc., unless the municipality opts out in accordance with the provisions of Section 5. We'll talk about how you opt out shortly. And then, as I mentioned, prohibits denial of any application on the basis of a district's character. And the issue, to what extent might this be deemed to affect landscaping or other soft regulations that are intended to preserve the ambiance of an area? So most of your landscaping regulations don't have fixed criteria. They have some general criteria, with the thought being that the commission can look at the general ambiance of the area, is the word I use, and figure out, well, what might be best for that particular area. But this business that you can't consider the character of the district unless it's expressly articulated by clear and explicit physical standards, I'm not sure whether landscaping regulations are going to pass muster with some courts on those grounds. So again, a problematic piece of legislative
David, you are.
articulation.
Join the meeting.
It eliminates the opportunity to set minimum floor areas, and it says by the applicable building, housing, or other code. And the issue is, what other code? I presume they might mean fire codes or something like that, but why didn't they just say so? What other code? Now it just leaves open a question for lawyers to fight about. We talked about it prohibits a fixed numerical or percentage cap on the number of dwelling units that constitute multifamily housing, et cetera. And again, the issue is just not as clearly worded as it might be, and it creates some ambiguities. It precludes the prohibition of any cottage food operation in a residential zone. And what I'm questioning is, does that mean, does the way it's written mean that you have no ability to verify compliance? If you are saying, okay, cottage food operations are allowed, cottage food operations have to be licensed by the state. But if you have to allow cottage food operations, do you get to ask a person first to prove that they have the state license in order to do it? Well, the legislation doesn't make that clear either. So now we've got an enforcement issue about cottage food operations. Does it mean that they can just start up with any kind of zoning review, or do zoning commissions still get to require some kind of an application for them? I suspect they probably do, because it says you can't prohibit them, but again, it's an ambiguity that we didn't need. All right, here's the opt-out process. Oops. Essentially, it's a two-step process. The zoning commission has to vote by a 2/3 vote after a hearing to opt out. And then if it does opt out, it's got to send the matter over to the municipality's legislative body, or if the legislative body is a town meeting, to the Board of Selectmen, for them to have the final say. So both the zoning commission and the selectmen or other legislative body have to agree to opt out of that parking provision. This is not as much concern to me for the parking provision as it is for the accessory apartment provision, which we'll talk about next. Now, the bill as written fails to repeat the reference to subdivision 9 of subsection D in the final sentence. And although a possible implication of that might be that the municipality can opt out of all of subsection D, I think a court would be unlikely to agree that that's the case. I think all you can opt out of is that parking provision. All right, now here come the accessory apartment provisions. You've got to bear with me on this, because this is very, very complicated. And the irony is you can opt out of the whole thing by essentially the same process we talked about before. All right, so an accessory apartment is a separate dwelling unit located on the same lot as a principal dwelling unit of greater square footage. It has cooking facilities. It complies with or is otherwise exempt from any applicable building code, fire code, and health and safety regulations. An affordable accessory apartment just means that it's one that meets certain affordability criteria. As of right means that the use is able to be approved in accordance with the terms of a zoning regulation or regulations, and without requiring that a public hearing be held or a variance, special permit, or special exception be granted, or any other discretionary zoning action taken other than a determination that a site plan conforms to applicable zoning regulations. All right. Now, any zoning remember, as you're reading this, you will when you get to the end of this, you will be able to opt out. But let's first talk about what happens if you don't. Any zoning regulations adopted shall designate locations or zoning districts within the municipality in which accessory apartments are allowed, provided at least one accessory apartment shall be allowed as of right on each lot that contains a single-family dwelling, and no such accessory apartment shall be required to be an affordable accessory apartment. And right off the bat, we've got a big ambiguity. It's not clear whether that requires commissions to designate areas in which more than one accessory apartment is allowed on a lot. Read it again. You have to designate locations or zoning districts in which accessory apartments are allowed, provided at least one shall be allowed as of right on each lot that contains a single family dwelling. You could interpret that to say, in those areas that you designate for accessory apartments, you have to allow at least one as of right. But you can also interpret it to say you can designate areas where they're allowed, but you have to allow at least one everywhere. It's not clear. So, and that was one of the, I am part of a group of municipal attorneys, and I was thinking, is it just me? When I'm looking at this, is it just me that finds this ambiguous? And within a day after this came out, there was just buzz all over the municipal attorney line with people asking the same question. Do you read this the way I do? What does this mean, this, or does this mean that? Terribly written. All right. Allow accessory apartments to be attached to or located within the proposed or existing principal dwelling, or detached from the proposed or existing principal dwelling and located on the same lot. So that means you not only have to allow them, you have to allow them as attached or detached units. And it doesn't give any kind of waiver of this. And one of the problems that I discussed on the right-hand side, if you have an existing dwelling that's already on a very small non-conforming lot, subsection A2, as well as subsection C, which I'll discuss later, would seemingly allow an as of right detached dwelling, even if it would badly exacerbate the existing nonconformities. Because it doesn't say anything about non-conforming lots. It says you have to allow them to be attached or detached. And so I'm thinking about some of these areas where you've got these tiny lots. You may have them around lakes or whatever. That's typically where you see them. And you've already got a unit there. And you know, the owner of the unit says, this is great because now I can add another rental unit onto my property. And I'll call it an accessory apartment. And you have to allow it according to this. All right, going to subsection 3. You have to set a maximum net floor area for an accessory apartment of not less than 30% of the net floor area of the principal dwelling, or 1,000 square feet, whichever is less, except that such regulations may allow a larger net floor area for such apartments. Okay, so you have to set a maximum net floor area of not less than 30% of the net floor area of the principal dwelling. And it illustrates what I call an odd grammatical structure that's used in much of the act. The regulations shall set a maximum floor area of not less than such and such, whichever is less, but the regulations may allow a larger net floor area. What? Again, if you try to read that grammatically, you're going to end up scratching your head, because it just sort of, it's written backwards. It's much more complicated than it needs to be. Subsection 4, require setbacks, lot size, and building frontage less than or equal to that which is required for the principal dwelling, and require lot coverage greater than or equal to that which is required for the principal dwelling. Now, what's interesting is this is saying the regulations shall require setbacks, lot size, and building frontage less than or equal to that which is required for the principal dwelling. Theoretically, you wouldn't have to have any setbacks at all for the accessory apartments. And here they're saying you have to require them to be less than or equal to what you require for the principal dwelling. So again, it's that backwards way of saying what they mean. But what's interesting to me is subsection 4 precludes municipalities from requiring accessory apartments to be behind the principal dwelling. And I know in a lot of municipalities, that's one of the things that they want. They don't want the accessory unit to be up front. They want it to be a little bit behind so that it de-emphasizes that particular unit. But now you're not going to be able to do that under this regulation, under this statute. And as I said, the second clause of subsection 4 is oddly worded. All right. Subsection 5, you have to provide for height, landscaping, and architectural design standards that do not exceed any such standards as they are applied to single-family dwellings in the municipality. It's not always clear whether a height, landscaping, or architectural design standard can reasonably be said to exceed a parallel standard for single-family dwellings. What does that mean, to exceed? Does that mean you can't have a wider buffer strip? Does that mean you can't require different vegetation in front of a 3-family than you can in front of a 1-family? Does it mean that you can't require, taller trees? It's just not clear what it means for a landscaping or architectural design standard to exceed another landscaping or architectural design standard, because by their very nature, landscaping and architectural design standards are not numerical. They're more aesthetic. So that's an issue. Okay. You can't be you're prohibited from requiring a passageway between any accessory apartment and any principal dwelling. You're prohibited from requiring an exterior door for any accessory apartment, except if the building or fire code requires it. You're prohibited from requiring more than one parking space for any accessory apartment. You're prohibited from requiring fees in lieu of parking that you would otherwise be able to charge under 8-2C. Here's a key one. You're prohibited from requiring a familial, marital, or employment relationship between occupants of the principal dwelling and the accessory apartment. That is a very, very common provision that most towns have, in my experience, that your accessory apartment has to be for members of the same family, or there has to be some relationship. That would now be forbidden by this statute. You can't require a minimum age for occupants of the accessory apartment. So it can't be for just parents. You can't require separate billing of utilities. I don't know why they have that. You can't require periodic renewals for permits for such accessory apartments. That actually makes sense. It never made any sense to me why a commission would be able to require a renewal of a permit for an accessory apartment. Except, I suppose, in some of those cases where commission's regulations say it has to be for somebody in the family, and the renewal of the permit gives the commission a chance to determine whether or not it's still within the family, or if the property got sold and the accessory apartment is no longer being used by somebody in the family. I suppose that might be one reason for that, but that would be made moot by the fact that you can't require a familial, marital, or employment relationship now anyway. Okay, now note that by eliminating the opportunity to require any relationship between the occupants of the two dwellings, the act is effectively providing for duplex housing as of right. Because what it's basically saying is when you've got this accessory apartment, except for the slight limitations on size that there may be, you can't require it to be any different from the other dwelling unit on the property. It can be separately owned. It doesn't have to have any relationship to the principal unit and so forth. So it's effectively, it's a duplex. Basically, they've allowed duplexes as of right under this statute. Subsection 7, the zoning regulations must be interpreted and enforced such that nothing in this section shall be in derogation of applicable building code requirements. The ability of a municipality to prohibit or limit the use of accessory apartments for short-term rentals or vacation stays, or other requirements where a well or private sewerage system is being used, provided approval for any such accessory apartment shall not be unreasonably withheld. The reference to short-term rentals and vacation stays is helpful. So now if the person that, buys a house with an existing accessory unit, it's now saying you can't rent it out for short-term rentals or vacation stays unless the zoning regulations allow you to do that. So at least that's something. But it's not clear how much latitude subsection 7C really provides for additional regulatory requirements in cases in which a well or private sewerage system is being used. Nothing in this section shall be in derogation of other requirements where a well or private sewerage system is being used. We're going to have to work through that. Nobody, at this point, the legislation is brand new, so nobody really means how much you'll really be able to get away with. All right. The as of right permit application and review process for approval of accessory apartments shall require that a decision on any such application be rendered not later than 65 days after receipt of such application by the commission, except that an applicant may consent to one or more extensions of not more than an additional 65 days. Number one, the phrase one or more extensions of not more than an additional 65 days is ambiguous. Does that mean you can have several extensions of 65 days? It's not clear. I think they meant you can't have a total of extensions that add up to more than 65 days, but didn't actually say that. I'm conservative, so I would say I wouldn't risk it. Figure that you only have 65 days after the original 65 days for extensions. The other thing that's important, I didn't note it on the right, but it says a decision has to be rendered on the application not later than 65 days after receipt. And what it doesn't do is refer to section 8.7D of the general statutes. Section 8-7D of the general statutes is the one that says the date of receipt shall be determined as the date of the next regularly scheduled commission meeting after the day of submission or 35 days later, whichever comes first. This doesn't reference 8.7D. It just says receipt. And so my belief is you better treat it as received the minute it comes in. You can't wait till the next commission meeting to start the 65 days. A municipality shall not condition the approval of an accessory apartment on the correction of a non-conforming use, structure, or lot. That's not terribly unusual. Or require the installation of fire sprinklers in an accessory apartment if such sprinklers are not required for the principal dwelling or otherwise required by the fire code. Subsections A and C suggest that detached accessory apartments could be required to be approved even if they badly exacerbate a non-conforming condition. Look at C again. Can't condition the approval on the correction of a non-conforming use, structure, or lot. So again, it's suggesting that if you have a lot where it's just badly non-conforming because of the existing dwelling on it, you can't stop a second dwelling from being built. And the second dwelling, in most cases, has to be allowed to be at least a pretty substantial dwelling. So if you're on a terribly small lot, this could create a lot of problems. A municipality, special district, sewer, or water authority shall not consider an accessory apartment to be a new residential use for the purposes of calculating connection fees or capacity charges. It's not clear to me why a separate utility connection or charge should be disallowed, even when the accessory apartment would be a detached dwelling that can be occupied by unrelated residents. If they were all tied together in the same family, I guess I'd say, okay, that's okay. But here, it could be a completely distinct family living in this accessory apartment, and you can't require a separate connection. I don't get it. All right, maybe it's just me. If a municipality fails to adopt new regulations or amend existing regulations by January 1 of 2023 for the purpose of complying with all of the stuff that we talked about already, and unless such municipality opts out of the provision of said subsections, any non-compliant existing regulation shall become null and void, and such municipality shall approve or deny applications for accessory apartments in accordance with the requirements of A through D, until the municipality becomes compliant with those subsections. And you can't impose or use additional standards beyond those in A to D. The issue is the statement says that any non-compliant existing regulation shall become null and void. That is highly problematic because, for example, if the regulation simply failed to provide for accessory apartments, what becomes null and void? Do the whole set of regulations become null and void because you didn't apply for accessory apartments? I don't think a court would ultimately do that. I think a court would try to read it sensibly and say, no, 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 no. What they must have meant was, to the extent you're not allowing accessory apartments, we're going to treat your regulations as being null and void. So perhaps the regulation that says you can only do what's specifically allowed in the regulations, that becomes null and void if it's used to stop somebody from having an accessory apartment because you don't mention them. So I think a court would probably read it that way, but again, badly worded, unnecessarily badly worded. So after all that, you want to opt out? I got to tell you, I'm suggesting that you do very strongly. And the reason is, you could adopt regulations. If you opt out, you can, and you want to encourage accessory apartments, you could do a much better job over the next year or more in implementing regulations that are clearly worded and say exactly what you mean. So my point is, I think you could do a much, much better job than the legislature did in coming up with provisions for accessory apartments. Now, I think ultimately, if a lot of towns opt out of this, and I think a lot of towns will because of all of these problems, the legislature may come back next year or the following year and say, well, that didn't work out so well, so we're gonna hit you with another one. But you know, what may come or may not come, there's no point in speculating until it does come. My suggestion is that you certainly start thinking about what you would want to do for accessory apartments. But I really think you should begin this process, or at least begin discussing opting out. Now, if you want to opt out, you have to go through pretty much the same process we talked about for that parking regulation, which is the zoning commission has to start by opting out after a 2/3 vote after a public hearing. So you have to have a supermajority of the commission that votes to opt out. And then you have to send it to your town's legislative body or selectmen for their vote. And they have to vote by a 2/3 majority to opt out. And again, my point of view is that even if you would be in favor of most of these provisions, if they were clearly or better written, you're still better off by opting out and drafting those regulations yourself, rather than allowing these to take effect and being subject to all of the ambiguities that result from that. And you don't have long to think about it. So start thinking about it now. All right, other provisions of Public Act 21-29, Section 7 amends the Affordable Housing Act to say that accessory apartments built after January 1 of next year are not to be counted for the purposes of calculating the total number of dwelling units in a municipality. unless they meet certain affordability requirements. So you have all of these accessory apartments that can be built. It's probably a good thing that you don't count them for calculating the total number of dwelling units, because if you did, your 10% threshold would be increasing as well. So you could have a bunch of accessory apartments, none of which are affordable, that are created, and you would have to set aside another tenth of those as your fair share of affordable housing. This prevents that from happening. So this is a good thing. Section 7 is a good thing. Section 8 amends Section 8-3E that says that the zoning commission shall provide for the manner in which the zoning regulation shall be enforced, except that any person appointed as a zoning enforcement officer on and after January 1 of 2023 shall be certified. And you have to be certified in accordance with the Connecticut Association of Zoning Enforcement Officials program. And you have to maintain that certification for the duration of employment as a zoning enforcement officer. What's interesting, and again, this just shows you sloppy drafting. I'm not on a soapbox or anything. I hate sloppy drafting. Beginning January 1, 2023, and annually thereafter, each person appointed as a zoning enforcement officer shall obtain certification. Well, guess what? Casio only certifies you once. When you get Casio certification, that's it. You're certified. You don't have to go back annually to get recertified. But this is saying annually thereafter, you shall obtain certification. So I suppose the way you could interpret that is maybe every year Casio has to at least send you a notice saying, your zoning enforcement officer remains certified or something like that. But otherwise it doesn't make any sense because there is no annual certification. It's just once and done. I don't know whether Casio has any way of losing certification. I've never heard of that. It's possible. It's a once and done thing. So unless Casio is going to provide annual notices to towns, I'm not sure how this annual certification requirement will work. But at any rate, it's new, and ZEOs have to have it. And I think you already have it, right, Donna? You have your certification. Yeah.
Yes, I do.
All right. Here's one you're going to love. Training of commission members. On and after January 1 of 2023, each member of a planning commission, zoning commission, combined commission, and zoning board of appeals, note the Inland Wetlands Agency is not included, has to complete at least 4 hours of training. Any such member serving on the commission as of January 1, 2023 shall complete the initial training by the following January and shall complete any subsequent training every other year thereafter. Any such member not serving on the commission as of January 1, 2023 has to complete the initial training not later than 1 year after the member's election or appointment, and any subsequent training has to be completed every year thereafter. And then it talks about what the training has to include. Not later than January 1 of next year, the OPM is going to establish guidelines for the training. And so we're not sure yet who's going to be authorized to provide the training. It says it could be Casio, it could be the Connecticut Conference of Municipalities, it could be the American Planning Association, it could be the Land Use Academy at the Yukon, it could be the Bar Association, it can be regional councils of government. If the secretary fails to establish such guidelines, the land use training may create, providers may create and administer appropriate training for members of commissioners and boards described in subsection A. There are a number of ways to obtain this training. Probably the easiest one is every 2 years, the Bar Association Planning and Zoning Commission has had or Planning and Zoning Section, I should say, has had a comprehensive program for training municipal land use officials. The difference is this talks about the training shall include at least 1 hour concerning affordable and fair housing policies. I think the affordable housing training in the Bar Association program has only been a half hour. So we might have to increase that in order for that to happen. And I know that other councils, the Council of Government in your area recently had a training program. So there are a number of ways of doing that. And I don't think if the OPM doesn't come out with guidelines by January 1, 2022, I don't think that's going to be very much of a problem. The problem is going to be, as you probably as you might know yourselves, and many towns know, it's not always easy to get people to serve on planning and zoning or wetlands or other land use commissions. And now, if they have to have biannual training, that may be the straw that breaks the camel's back for a lot of commission members. A lot of commission, even though it doesn't seem like a lot, 4 hours is a lot of time for somebody to spend on a Saturday or whenever. And a lot of commission members may say, I just don't want to do that. I really don't want to do that. I'm giving my time already. I'm giving multiple hours a month to do this. I don't feel like I'm going to have to do that. So we'll have to wait and see how much commission members respond to this negatively and see whether people start dropping off. But otherwise, that provision is going into effect. Not later than March 1 of 2024, each of those agencies has to submit a statement to the municipality's legislative body or selectmen affirming compliance with the training requirement. The issue, what is the penalty for non-compliance? The statute doesn't say. What if there are not enough trained members to constitute a quorum? Doesn't say. What will the agencies be able to proceed? Will their decisions just be overturned? Doesn't say. Any one of those things could happen, could be a result. Certainly, one of the very strong possibilities is a court could say whoever does not have this statutorily required training cannot sit as a member of one of those agencies. And so if that member says, I'm sitting anyway and I'm going to participate, what the chair of that commission is going to have to do, assuming that the chair is properly trained, is going to have to say, we're going to have to discount your vote. We're just not going to include your vote in the total count. We're going to have to get that vote some other way. That's a very likely result of this. So problems yet to come, perhaps. All right, section 10 of 2129, excuse me, amends section 7-245 and 7-246. 11 does that, of the Water Pollution Control Authority statutes that define community sewerage system and talk about what they can do. I'm not going to go over those because I don't think we have any WPCA members on the line. It amends, section 12 amends 830J to require copies of municipal affordable housing plans, which are already due by June 1st of next year, and they're required to be revised every 5 years. Copies now have to be submitted to the OPM, and copies of any draft plans have to be posted on the municipality's website. Section 13 establishes a commission on Connecticut's development and future. We won't talk about that because that's a state function that's going to be created. So I'll just leave you to review that at your leisure. Okay. Public Act 21-34. This one basically extends approvals that have already been granted for long periods of time. So I'll, each one, I'll just go over them quickly separately. 22A, 42A D2 of the Inland Wetlands Act. Any permit, well, this one's slightly different. Any permit shall not take effect until each other approval granted under chapter 124 or 124B, 126 or 126A. Those are all planning and zoning statutes. So any other planning or zoning authorization that has to be required has to be granted before the effective date of the inland wetlands permit, the comparable inland wetlands permit. And from that date on, it's valid until the approval granted under that chapter expires or 10 years, whichever is earlier. So if the zoning permit expires in 2 years, the wetland permit expires in 2 years. If the zoning permit expires in 15 years, the wetland permit expires in 10 years. That's basically what that's saying. So that's the only thing that's a little bit different in this laundry list of statutes. 8-3M, site plan approvals that did not expire, that were made after July 1st of 2011, but did not expire prior to March 10th of this year, except certain approvals made under subsection J, get 14 years from the date of approval, with the commission being able to grant one or more extensions of time to complete all or part of the work in connection with such site plan. I'm going to go through these very, very rapidly because they're all very, very similar. All right. 8-26 CE, part of the subdivision statutes. Any subdivision approval made after July 1 of 2011, but that didn't expire prior to March 10, shall expire not less than 14 years after, and extensions can be provided, except that the extensions can't be for a longer period than 19 years after the date of approval. 826 GC, basically the same thing for projects consisting of 400 or more dwelling units. 22A, 42AG, essentially the same thing for inland wetlands permits. 8-3, any special permit or special exception approval made on or after, et cetera, basically the same thing. 8-26E, again, part of the subdivision rules, although actually, that's not a subdivision rule. It's in the planning statutes, but it's that statute that allows the zoning regulations to designate the planning commission, if you have a separate planning commission, as an authority to issue special permits or special exceptions. I don't actually know any town that does that. I don't know any town that has a separate planning agency that they've designated to do special permits or special exceptions. But if you happen to have one of those, same thing. Section 9 is basically a catch-all. If we didn't get you before, then we're going to get you here. Notwithstanding the provisions of any special act or any site plan, subdivision, permit approval by a zoning commission, blah, 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 that occurred that occurred after July 1, but didn't expire prior to March 10, 2020, et cetera, et cetera. It's the same thing. I think that was meant because in some instances, towns are not operating under the general statutes. They're operating under special acts. So I think this catch-all was intended to say, if you're one of those special act communities, you're bound by these extensions as well. And there's pretty much the same thing there. So all of these are extensions. And again, you can read them at your leisure. I won't spend a lot more time on, I won't spend any more time on those. All right, Special Session Public Act number 21-1. Now we're into marijuana legislation. Don, I know we've gone an hour. Do you want me to take a 5-minute break or what?
Nope, these
Okay.
guys are good. They're tough.
Keep on going. Okay, the marijuana legislation, Section 83. Upon the petition of not less than 10% of the electors of any municipality, the selectmen of the municipality shall warn the electors that a vote shall be taken to determine whether or not the recreational sale of marijuana shall be permitted in the municipality, or whether the sale of marijuana shall be permitted in one or more classes of license of cannabis establishments. And then it talks about how the ballot labels have to be prepared. So the basic thrust of that is a special meeting can be petitioned for a determination to be made by the municipality whether to allow this or whether not to allow this. No municipality shall prohibit delivery of cannabis to a consumer, qualifying patient, or caregiver when the delivery is made by a retailer, hybrid retailer, dispensary facility, delivery service, micro cultivator, or other person authorized to make such delivery pursuant to RURACA, which is the cannabis legislation. No municipality shall prohibit the transport of cannabis to, from, or through such municipality by any person licensed or registered pursuant to the act to transport cannabis. So you can limit or regulate or prohibit certain types of cannabis businesses in town, but that doesn't allow you to prevent the delivery of the cannabis from somebody who's not coming from a service in town or from an agency in town, or by any person who is authorized otherwise to make that kind of delivery to a person. No municipality or local official shall condition any official action or accept any donation in monies or in kind from any cannabis establishment or from an individual or corporation that has applied for a license to open or operate a cannabis establishment in such municipality. So you can't have somebody who's saying, look, if you grant me this license, we'll make a donation to the local school, or, that kind of thing. No municipality shall negotiate or enter into a local host agreement with a cannabis establishment or a person that has applied for a license to open or operate a cannabis establishment in such municipality. So you can't talk about, here's what we're going to do. You can't get together with a proposed cannabis establishment and say, here's what we're going to do to make you the person that becomes the cannabis establishment in this town. The state is kind of reserving its rights at this point to figure out who might get licenses to do these things and presumably where they may operate. So there's a little bit of a limitation on what the municipality can do there. And then for up to 30 days after the opening of a retailer or hybrid retailer, a municipality may charge such retailer or hybrid retailer for any reasonable and necessary costs incurred for provision of public safety services in relation to such opening. And I think they're assuming that once a retailer or hybrid retailer opens in the town, what's going to happen is you're going to get a parade of vehicles, and it's going to cause, traffic jams or whatever. And so I think it's basically saying towns are going to have to get their police force ready to monitor that or do something about that. They may have to hire some off-duty cops and pay them, or pay cops overtime or something like that. And they want municipalities to be able to charge the retailer for that. All right. Under Section 84, also Section 7-148 of the general statutes is amended. 7-148 is the section of the general statutes that provides most of the authority for a town to adopt ordinances. So it doesn't affect zoning regulations, planning regulations, or inland wetlands regulations. It's just ordinances that would be adopted by the municipality as a whole, in Kent, presumably by town meeting. So it's been now amended to say that you can regulate, this is a new provision, you can regulate on any property owned or by or under the control of the municipality any activity deemed to be deleterious to public health, including the burning of a lighted cigarette, cigar, pipe, or similar device, whether containing tobacco or cannabis, and the use or consumption of cannabis, including but not limited to, et cetera, et cetera. So basically, you can limit where on public property cannabis can be smoked. You can prescribe penalties for the violation of those regulations, provided the fine does not exceed $50 for a violation regarding consumption, or a fine in excess of $1,000 to any business for a violation of such regulations. But here's an important part. If the municipality's population is greater than 50,000, obviously that doesn't apply to Kent right now, such regulation shall designate a place in the municipality in which public consumption of cannabis is permitted. So you're not bound by that. All right, Section 148. Subsection A is pretty clear. Any municipality may, by amendment to the zoning regulation, prohibit the establishment of a cannabis establishment, establish reasonable regulations regarding the hours and signage, or establish restrictions on the proximity of cannabis establishments to any of the establishments listed in a different general statute, and that's basically churches and schools and that sort of thing. The chief zoning official shall report in writing any zoning changes adopted by the municipality regarding cannabis establishments pursuant to this subsection to the Secretary of OPM and to the department as public health not later than 14 days after the adoption of such changes. So ZEOs, if you do adopt regulations regarding marijuana, OPM wants to know about it, because they're trying to figure out how this is all going to shake out at this point. A cannabis establishment means a producer, dispensary facility, cultivator, micro-cultivator, retailer, hybrid retailer, food and beverage manufacturer, product packager, delivery service, or transporter. There are the establishments I mentioned from the preceding section right in here. Restrictions on the proximity to any of the establishments listed in subsection A of 3046. There they are: church, public or parochial school, convent, etc. Unless otherwise provided for by a municipality through its zoning regulations or ordinances, a cannabis establishment shall be zoned as if for any other similar use other than a cannabis establishment would be zoned. There we go. Ambiguous as all heck. What does that mean? What is a similar use to a cannabis establishment? Arguably, there isn't any similar use to a cannabis establishment. So we don't know what that means. But I think what it means is, if you're talking about somebody who wants to sell cannabis and you allow, generally speaking, retail sales in a district, then if you don't have specific regulations regarding cannabis, retail sales are going to include retail sales of cannabis. If you say sales of books, if that's what you allow in a zone, sales of books, then, you know, nobody's going to say, well, it's less likely that somebody's going to argue, well, sales of cannabis is similar to that, because the argument against that would be, no, if they meant to allow all kinds of sales of different things, they would have said so, but they're only allowing sales of books. But most towns, and I think Kent does, have some areas where it says you can have retail sales. Cannabis will fit into that if you allow it. And we'll have to go through some of the other, a trucking facility, or if you allow a storage facility. Certain cannabis establishments may fall into those provisions. So you're going to have to start thinking about regulation of cannabis and how you'd want to do it. There are many towns right now that are going through the process of amending their regulations to disallow any cannabis establishments in their town, at least for the time being, until they can figure out what they want to do. Many towns are already in the process of doing that. A lot of towns are in the process of doing it in a way that I don't think will stand up in court. I think in order to do it, the zoning commission would have to go through the same process it would go through to amend its regulations. Even if you want to just create a moratorium, I think that's a regulation amendment process. The good news is, until the state gets its whole licensing apparatus up, it's very unlikely that somebody is going to be in a position to get licensed and be coming to Kent with an application very, very quickly. But the faster you do this, the better. If you don't want these things in town, or you're not sure you may want them in town, the faster you get this done, the better. You can see subsection D, any restriction regarding hours, zoning, and signing of a cannabis establishment adopted by municipality shall not apply to an existing cannabis establishment located in the municipality. So that means, again, if somebody slips through the door while you're still working on your regulations, now you're stuck with them. Until
Mike?
June, yeah.
Maybe we can do this offline tomorrow, but maybe can we talk about how to go about doing a moratorium? Aren't there a lot of towns that are doing that now?
A lot of towns are doing moratoriums, but they seem to think that somehow or other a moratorium is different from a typical zoning regulation. So I have heard that some towns have already adopted moratoriums, or they adopted moratoriums within, 30 days after the legislation came out. And the problem I have with that is you can't possibly meet all of the statutory requirements with 30 days. So they must have just adopted this and said, we're voting to establish a moratorium. And they think we don't have to go through the regulation process to do that. But you can only address uses in your community through regulation. So you have to go through the regulatory process to adopt a moratorium. That's my point of view. So my feeling is, all it would take is a vote on a proposed new regulation saying no cannabis establishments as defined in, section, whatever the section is, section 1 probably of Special Session Public Act number 21-1 shall be permitted in the town of Kent, period. You send that to the CROGs or the regional planning agencies that you have to send it to. I don't think you have to send it to neighboring towns because it doesn't affect any particular property in the town. And then you have your hearing and you vote on it and you do the public notices. So I think it's a process that shouldn't take you any more than, if you did it really fast, you could probably get it done in a month, but certainly it shouldn't take you any more than a month and a half. I don't think anybody's going to be licensed by the state within that time frame. They're still trying to figure out how they're going to go about the licensing process. Don't forget, they want to make it easier for people from the inner city to get licenses. They wanted to have this equity kind of thing where people that are most affected by the criminal policies that used to exist on marijuana, they want them to have the first opportunities to get licensed. So I'm thinking that it's very unlikely, it seems to me, for anybody to be able to be ready to come into your town within the next month or two to get a permit for a cannabis establishment. And then even if they came in, they said, well, we're going to come in and you could say, well, we don't have anything in town at this point that allows cannabis establishments, so we're going to say no. Or even if they got the permit, I suppose you could issue the permit and say this is subject to,
State licensing.
that the permit is issued, provided that you have to be up and running by, within a month or something like that. There are ways to deal with it, but I really don't think it's going to happen.
Okay, so you're suggesting what we should do is make a change to the regulation, and then when somebody comes in, it would be their responsibility to actually propose a change to the regulation to allow this to happen.
Right. Or if
Okay,
the commission decided at some point that, all right, let's allow it. Let's see what happens. Let's allow some type of use. The commission could do it on its own. But yes, if the commission didn't, then somebody would have to come in and do it. Now, here's one of the problems that I have. We went over that section 84 before, which talked about the town can have a referendum to decide whether or not the sale shall be allowed in the town. And so the question I have is, well, what happens if the referendum says yes and the zoning commission says no? Does one, do you have to get both in order for that to happen? Certainly the zoning commission could put in a regulation allowing it. And if the ordinance came in and said the town can't allow it, the ordinance would win, because a person has to, wouldn't be able to do it. Certainly under that, but it's unclear whether the ordinance would supersede any contrary vote that the zoning commission would take. We don't know yet. And again, it's, the legislature easily could have made that clear by saying such an ordinance will supersede, or such a vote shall supersede any vote by the zoning commission not to allow it in town. But it's not clear. Did I go over that one? Okay. On and after July 1 of 2024, the Commissioner of Consumer Protection may, in the discretion of the Commissioner, post on the internet a specific number of residents such that no municipality shall grant zoning approval for more retailers or micro retail. Basically what that means is, up until now, a town the size of Kent, even if it wanted to, couldn't allow more than one retailer or one micro cultivator. That's all you could do right now. On and after July 2024, the Commissioner of Consumer Protection could come up with some regulations that allow more than that. But unless and until the commissioner does that, Kent, even if it wanted to, couldn't have more than one retailer or one micro cultivator. For purposes of ensuring compliance, a special permit or other affirmative approval shall be required for any retailer or micro cultivator seeking to be located within a municipality. A municipality shall not grant such special permit or approval for any retailer or micro cultivator if that would result in, and then if you exceed the density cap, and it again talks about that same thing. And you can see the density cap of one retailer and one microcultivator for every 25,000 residents. So you're under that. So that's all you could be able to allow. Now, it doesn't really say what it means by a special permit or other affirmative approval. And there were questions going around on the municipal attorney's website saying, do they mean the normal kind of special permit? The one that you requires a public hearing and those kinds of things? Or are they talking just generally about some permit that's special because it's for cannabis? Because it says a special permit or other affirmative approval. Why would they mention a special permit specifically, which requires a public hearing, if other affirmative approval is also allowed, which could be just site plan approval? I think all this really means, though, is that nobody can come for a state license unless the applicant has gone through a specific process that gets a written approval from somebody in authority, whether it be a zoning enforcement officer or the commission. There has to be a formal decision that's made. The retailer or microcultivator can't just come in and say, oh, the regulations allow it as of right. So, I don't need to get any kind of a permit because it's as of right in this town. Under this portion of the statute, the state would say, yeah, it's too bad. You have to go get some kind of a written permit in order for this to apply. That wouldn't be a problem in Kent because permits are required for virtually any use, I think. So certainly they would be for any kind of retail or retail uses. And with regard to cultivation, we'll get to this I'll show you in a second, but the Act defines agriculture. They've added to the definition of agriculture and farming to exclude cannabis cultivation. So nobody can come in and say, I'm a farmer, I'm growing cannabis. That doesn't work. And there it is, section 143. The terms agriculture and farming do not include the cultivation of cannabis as defined in section 1 of this act. So if you haven't defined agriculture specifically in your regulation, and somebody comes in relying on the state regulation, which is very, very broad, the state definition, at least it now does not include cannabis. Okay. Now we're going into the implementer bill. And the implementer bill is largely important because of what it has done with regard to hybrid and electronic meetings like the one we're having right now. It adds new definitions to the Freedom of Information Act about electronic equipment and electronic transmission, which I'll allow you to read at your leisure. Section 149, on and after the date of this section, until April 30th of next year, a public agency may hold a public meeting that is accessible to the public by means of electronic equipment or by means of electronic equipment in conjunction with an in-person meeting, i.e. a hybrid meeting. So you can have a purely electronic meeting or a hybrid meeting up until April 30th of 2022. Not less than 48 hours before you have a regular meeting by means of electronic equipment, the agency has to provide direct notification in writing or by electronic transmission to every member of the agency and post a notice that such agency intends to conduct the meeting either solely or in part by means of electronic equipment in the agency's regular office or place of business, in the office of the clerk of the municipality, or in those two places. Okay, the others talk about state and other quasi-public agencies. And if the agency has an internet website, on the internet website. So 3 different places it has to be posted. Not less than 24 hours, so that's 48 hours. You've got to give notice to every member. Not less than 24 hours prior to any such meeting, the agency shall post the agenda in the same manner as the notice of the meeting. not less than 48 hours before you have an electronic meeting, and it doesn't say in this case by means of electronic equipment or partially, but I assume it means that. The agency shall provide direct notification in writing or by electronic transmission to each member of the agency and post notice that the agency intends, oh, wait a minute, did I copy the wrong thing? I'm sorry. It looks like I mistakenly copied the same section of the statute. I'm going to have to fix that. Sorry about that. The notice and the agenda shall include instructions for the public to attend and provide comment or otherwise participate in the meeting by means of electronic equipment or in person as applicable and permitted. I actually think this was just a mistaken repeat. I don't think there was anything else that went in there. Okay. Any public agency that conducts a meeting solely by means of electronic equipment shall provide any member of the public upon a written request not less than 24 hours prior to the meeting with a physical location and any electronic equipment necessary to attend such meeting in real time. So if you're going to have an electronic or hybrid meeting, you've got to provide anybody who asks for it at least one day in advance, with a physical location and the equipment to be present electronically. Wow. You have to provide them with the same opportunities to provide comment or testimony and participate that any member of the public who's attending physically would have. It doesn't mean that you're required to allow them to speak if they otherwise wouldn't have the ability to speak. So if it's just a commission meeting, not a public hearing, this doesn't mean that you have to let them speak. Also, a public agency is not required to adjourn or postpone a meeting if a member of the public loses the ability to participate because of an interruption, failure, or degradation of the connection by electronic equipment. You have to ensure that the meeting is recorded or transcribed. That's same as what you're doing now, and it has to be posted on the internet website of the agency and made available to the public to view not less than 7 days after the meeting, and for not less than 45 days thereafter. If a quorum of the members of a public agency attend a meeting by means of electronic equipment, you have to permit members of the public to attend the meeting in that same physical location. So if you're having a Zoom meeting, but 5 members of the commission show up in a particular room to view the Zoom meeting, you have to let the public in too. Any public agency that conducts a meeting shall provide members of the public agency the opportunity to participate by electronic equipment. Now, this one is an interesting one. And again, there are questions going around the municipal attorney's website. What does this mean? Does this mean that any one member of the agency can demand that the meeting be held by Zoom? Most of us on that website don't think so. Most of us think what that means is, if any member of the commission wants to attend electronically, then the agents, even if the commission is not planning to have an electronic meeting, is not having a hybrid meeting or a Zoom meeting, just a regular in-person meeting. If any member of the agency wants to attend electronically, you have to make a provision for them to do that. But notice what it says. You have to provide the opportunity to participate by means of electronic equipment. Theoretically, that could be telephone only. And again, except that if a public agency, you're not required to adjourn or postpone it if the member loses the ability to participate, unless the member's participation is necessary to form a quorum. So again, we don't think that means that any member of an agency can demand a Zoom meeting. We think it simply means that even if it's a public, in situ meeting, generally speaking, that any agency member has the right to connect to the meeting electronically. And the agency has to provide some way to do that, whether it's somebody's cell phone sitting on top of the table or some other way for the member to do that. Now, I would give you some warning in doing that, though. And that is, if that should happen, if somebody is coming to that meeting and laying out plans or maps or other graphical materials that you're seeing as the agency for the first time, and you've got somebody on the telephone, and that somebody wants to be a part of the quorum and is a regular member, you shouldn't decide that night on that, whatever that application or whatever that matter is, because that person arguably would not have had the ability to really review a critical part of the file. If the site plans or other graphic materials are critical materials, then that person, without seeing them, arguably can't responsibly vote. And if the person voted anyway, if you held a vote and that person voted, I think a court might overturn it, because that they would say that agency member was not able to familiarize himself or herself with the entire critical record. And so I don't recommend that. Now, if the graphical materials that are submitted are really not all that critical, let's say somebody submits a photograph of something that you can describe. Here's a photograph that shows such and such. Or it's a chart that you can describe, or some other kind of thing that you can describe adequately, verbally, then you might be able to vote that night. But you have to be very, very careful if you're going to do that.
What's the difference between what you just said, where the commission is meeting in public, the agency is meeting in public with each other, and one person wants to participate via electronic means? What's the difference between that and a hybrid meeting? Isn't that the same?
Well, the hybrid meeting, in a sense it is, but the hybrid meeting, the way that the statute is worded, we think it means that we're going back here. Well, let me go back even further. On and after the effective date of this section until April 30th of next year, a public agency may hold a public meeting that is accessible by the public by means of electronic equipment or by means of electronic equipment in conjunction with an in-person meeting. We think, reading that, it means the agency gets to decide whether it's an in-person meeting or an electronic meeting or a partial electronic meeting. The agency gets to decide. And so if you were to read that position, that other provision that says you have to, and members of the agency the opportunity to participate. If you read that to say any member can demand that it be an electronic or hybrid meeting, that defeats kind of the purpose of the agency making the decision. The agency never gets to make the decision. One person could make that decision for the agency up until April 30th of 2022. We don't think that's what was meant. So hybrid in this sense, a hybrid meeting in this sense means a meeting that the agency itself determined was going to be available by electronic means, such as Zoom. And the agency would provide presumably Zoom or some other visual form of communication, as you're doing tonight, to allow documents to be viewed and so forth. But if a member of the agency asks to have the ability to connect electronically, notice it doesn't say how you have to allow them to connect. It just says that you have to provide them the opportunity to participate by means of electronic equipment. So I think that was basically saying, if you've got one or more commission members who are not comfortable, still not comfortable with getting together and, being less than 6 feet apart and all, without masks and stuff like that, that we want to accommodate that person for at least a limited amount of time. But that doesn't mean that the agency has to go through all of the other processes that it would to conduct a Zoom or a hybrid meeting. So that's the best I can answer for that, Donna.
All right, thanks, Mike.
You bet. Any vote taken at a meeting during which any member participates by means of electronic equipment shall be taken by roll call unless the vote is unanimous. It's kind of silly because if you're doing a vote electronically with somebody participating electronically, there's no way, if you say, okay, all in favor, if you hear a chorus of ayes, there's no way you're going to know whether the person on the phone was part of that or not. So that person is going to have to be individually asked, do you vote yay or nay? And once you've done that, you might as well, I suppose you could say, all right, all those in favor, aye. And if everybody at the, who's present says aye, and then you say to the person on the phone, what's your vote? And they say aye, then I suppose it doesn't have to be by roll call. But why not just have it by roll call? Just make it easy on us. All right. The minutes of the meeting shall record a list of members that attended such meeting in person and a list of the members that attended such meeting by means of electronic equipment. I think you would normally do that anyway. Any member of a public agency or the public who participates orally in a meeting conducted by means of electronic equipment shall make a good faith effort to state such member's name and title, if applicable, at the outset of each occasion that such member participates orally during an uninterrupted dialogue or series of questions and answers. So again, this is one of the reasons why I think if it's just one member asking me to be connected individually, this wouldn't normally apply. Because if you only got one person on the phone, there's no reason why every time that person speaks, they have to say, this is blah, 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 when nobody else is necessarily doing that. I think it's always a good idea during a public hearing, just for the person who's transcribing public hearings, to say your name, if there's a question and answer, and it's not obvious to say your name at the beginning of a new thought. But I don't think it's really necessary if you have one person on the phone. I don't think it's necessary for that person to be singled out to, every time that person speaks. It's actually probably easier at that point to figure out who's speaking if it's only one person on the phone. Anyway, that's what it says. Okay. Whenever a meeting being conducted by electronic equipment is interrupted by failure, disconnection, or, in the chairman's determination, unacceptable degradation of the electronic means of conducting a meeting, you have a storm going on and the transmission is going bad, or if a member necessary to form a quorum loses the ability to participate, the agency may, not less than 30 minutes and not more than 2 hours from the time of the interruption, resume the meeting if the quorum is still present or if the quorum is restored by means of electronic equipment. The public agency shall, if practicable, post a notification on its internet website and inform attendees by electronic transmission of the expected time of resumption or of the adjournment or postponement of the meeting as applicable, and may announce at the beginning of any meeting what pre-planned procedures are in place for resumption of a meeting in the event of an interruption. I think that's the best part of this. Tell people in advance, if this gets interrupted, here's what we're going to do. Hang on for 30 minutes. If we're not back on in 30 minutes, look on our website and we will try to post on our website when we're going to resume the meeting, if we're going to resume it tonight. Something like that. Or maybe it's let's see what we do in the next 15 minutes. It could be as simple as that, but it's a good idea to tell people in advance, because once they're disconnected, how do you get to them? How do you get to tell them what you're going to do? Nothing in this section shall be construed to require a public agency to offer members of the public who attend a meeting by means of electronic equipment the opportunity for public comment, testimony, or other participation if it's not otherwise required. So again, as we talked about, if you had just a regular meeting of the commission where the public is not entitled to comment, the fact that they're connecting electronically doesn't make any difference. Special Act 21-3. I'm not going to talk too much about this because I think, Donna, you know as much about this as you already need to. It continues the COVID-19 responsive fast track system for approval of outdoor service by food service establishments. As many of you know, the governor executive orders, when there was substantial concern about outdoor food service establishments going belly up during the pandemic, the governor issued an executive order that made it a lot easier to get outside seating if your zoning regulations didn't already allow outside seating. And basically it created a process where there's a fast track approval for outside seating at an existing restaurant, where all the person has to do is go to the zoning enforcement officer with a sketch plan or something like that and say, here's where I want to have outside seating. And the zoning enforcement officer is entitled to authorize that, or at least, at very least, a decision has to be made on that application very, very quickly. And generally speaking, if you have an outside restaurant, you've got to be able to have the outside food service, and the commission is limited to sort of figuring out how to do that in a way that's not going to cause problems for the general public. There's very limited information that has to be provided. The CEO can ask for more if she feels that, it's inadequate to make a decision. So again, those provisions have been in existence since last year. This continues them until March 31st of next year. Public Act 21-101 allows the Housing Finance Authority to establish affordability incentive zones in municipalities which haven't achieved the 10% threshold under the Affordable Housing Act to incentivize purchase of homes using CHFA mortgages. And so we don't have to know too much about that, but I threw that in because it does involve affordable housing. 21-13 Special Act, there's a working group under the Department of Economic and Community Development to talk about historic preservation and figuring out a plan for supporting efforts by municipalities, historical societies, and other nonprofit entities to do that. Gosh, see what I mean? It's 7:45 already. We've been talking about this for 1 hour and 3/4, and I flew through this. So, wow. I'm going to turn it back over to you, Donna. You tell me what you want me to do now.
I don't know. I mean, there are members that are actually here from commissions, but there's also some people that are here that just work in the town hall that might be responsible for setting up meetings. And Steve Penner is asking me if we can ask questions. So I'm assuming that this is the best time to do that.
Yeah,
So Darlene and Joyce and you guys, if you want to go ahead and ask any questions. Connie, Mike did send me the PowerPoint presentation, and I will put that up on the town's website so that it can be viewed by those who were not able to make the meeting tonight.
And Don, I also have a PDF for people who don't have the PowerPoint program.
Okay, and I have both of those.
Okay.
Yep.
Yeah,
So-
go ahead, Steve.
Thanks, Mike. That was great. Just a couple questions right from the beginning. You brought up that the state basically eliminates the opportunity to set minimum floor areas. We have HOAs in the town of Kent that require a certain amount of square footage. I'm assuming that's the same thing as floor area. Is this
Yeah.
basically stating that the HOA cannot mandate minimums?
What it seems to be saying is that, yeah, if there is unless there's a building code or fire code or other state code requirement for minimum floor areas, that's no longer something that a zoning commission is entitled to do.
So that would also mean an HOA, right?
When you're saying HOA.
Like a homeowners association. So St. John's Peak requires all houses to be.
Oh, so a homeowners association. No, there's nothing in this that prevents a homeowners association from doing anything. This is just something that the zoning regulations no longer can do.
So like St. John's Peak is a homeowners association, their
Right.
own rules and regulations.
Yep.
They're still allowed to.
Oh, yeah, that's a private agreement. That's a
Okay.
private agreement. Doesn't take away the ability of private landowners to do this.
Okay. And then also you said that this, the new language prohibits fixed numerical number of units for multifamily.
Correct.
Just talk about that a little bit more.
Yeah. I don't know any town that has actually done this, but there are some towns that, for instance, have put numerical caps on certain types of uses. For instance, there are some towns that say we're not going to have more than 3 shopping centers, or, in a particular district, we're not going to have more than 3 shopping centers or something like that. Some towns have done stuff like that. I suppose by the same token, some towns could theoretically say, we don't want more than 20 buildings in the town of Kent that have 3 or more dwelling units. Like I say, I don't know any town that's actually done that in terms of residential development. What they've typically done is said, in this zone, you can have multifamily housing, and in this zone, you haven't. And so that's how they've restricted it, in a sense, how much multifamily housing can be created, by restricting the area where it can be created. But that particular portion of the statute was saying you can't put a number on it. You can't say only 20 buildings of 3 or more units or something like that. And like I say, I think that's going to have very little impact, because I don't know many towns that do it.
So I interpreted it differently. I thought it
Oh,
meant to
okay.
say that you can't put a cap on the number of units in a multifamily building.
I'm going to have to go back and take a look at that. I didn't read it that way, but you might be right. You might
Yeah.
be right. I'll go back and take a look at that.
Okay, thank you. That's it for me.
So are we assuming that with regard to the hybrid meetings, that that's going to be ending whenever 2022 or 2023? That at that point in time, we're just going to go right back to regular in-person meetings with no hybrids, with no recordings, you know, that kind of thing. So is that the assumption, because there's an end date on it?
No, I wouldn't say that. I don't think at this point we can say that, because right now I know there has been a lot of comment and discussion among members of the bar, planning agencies, and, you know, a variety of commissions as to the pros and cons of allowing these kinds of meetings to take place. There are some people who feel very strongly that this was a benefit, that it makes it a lot easier for people, because now you don't have to worry about driving in a storm or driving, you know, many miles to get to a particular location to participate in a meeting. But there are other people who feel that no matter how good the electronic connection is, being able to see things like maps and plans fully laid out, as opposed to on an 8x11 screen or something like that, has a lot of benefit. And also that, you know, if you're in a public situation, lots of people are not really very, very comfortable with doing more than connecting to the electronic meeting. So they may not know how to electronically raise their hands, or, you know, things like that. And so anyway, what I'm saying is there's back and forth about, is this a good thing or is this not a good thing? And that question hasn't been really answered by the legislature permanently. So I think they're saying, for now, let's keep this going. Let's get another 8 months of data on whether this has been a good thing or a bad thing. And then we'll decide whether we want to continue to allow it or not. I suspect, Donna, that they might very well say, you know what, this has worked out well enough that what we're going to do is leave it in the hands of individual commissions to decide whether they want to do it this way or not.
Okay. All right. And the other thing, does any of this specifically address the village districts? You know, we've got the Architecture Review Board that deals with character and characteristics. So what's the tie-in to, like, in ARB with the village consultant? And that kind of
Yeah. I think village districts have had their own specific regulation anyway, 8-2J, I think, that allowed them to consider things that might not be allowed to be considered under general regulations. But if you look at that, it really doesn't say that you can consider, if you have something in a village district, that you can consider character as a more amorphous quantity than you could under 8-2. I think even under a village district situation, your regulations would have to be relatively specific as to the kinds of things that you're looking at to determine whether or not a permit should be allowed. So you'd have to talk about you know, the style of architecture that's prevalent in that area, or maybe a particular architectural feature that's required, or a color that's required, because generally speaking, the zoning regulations don't talk about color. So you would have those various things that you might be able to consider in a village district that you couldn't consider in general regulations, but you'd still have to talk about them as more than just an ambiguous character thing. I don't
Okay.
think you could say, because you're in a village district, we get to consider character, and anything that we think is character qualifies as character. I don't think that would fly.
Okay. Anybody else? You guys are exceptionally quiet.
Well, I bludgeoned them to death.
Oh, all right. Nobody has anything else?
No, just thank you.
My pleasure.
A lot to take in.
Yeah, no kidding. No kidding. All right. Well, look, what I'm going to do, what I will do is I will look at that question that Steve asked a little earlier, and I'll just send Donna a follow-up by email. And Donna, you can mail it to Steve and, you know, anybody else who was interested in that question.
Okay,
And I'll do that tonight before. Well, I'll do that before the end of the night. I'll do that after we sign off.
okay.
I'm too dumb to do it while we're on the Zoom call. I can't chew gum either.
Okay. Connie, did you have anything that you wanted to ask? No? Okay. You're welcome. All right, then.
All right.
Thank
Thank
you.
you.
Thank you so very much for spending time with us.
My
I'm
pleasure.
sure you will be hearing from me
Oh, no, I doubt that very much.
with just some questions about how we should handle certain things, but
Okay.
this has been wonderful. It really has.
All right. My pleasure.
Thank
you, Mike.
Thank all for your patience.
Thank you.
Thank you, Mike.
Thanks a lot, Mike.
Thank you,
Okay,
Donna,
bye.
for inviting me.
Okay, thanks everybody for coming.
Okay.
Bye.
Good night.
Bye. Good night.
Bye.